Hello, everyone. Welcome to the 2025 Hot Topics and Environmental Law Summer Lecture Series. I'm Christophe Courchaine, Faculty Director of the Environmental Law Center, Associate Dean for Environmental and Experiential Programs here at Vermont Law and Graduate School. We're pleased to welcome you to the series this summer, which runs weekly through July. Each talk in this series is worth one Vermont CLE credit, so please keep track which talks you attend for your records. We'll have some time for Q&A after today's presentation. So for those of you watching on the VLGS YouTube, please enter your questions in the chat space on the right. At any time, I'll convey those to our speaker, and we'll get through as many as we can. So today, we are beyond pleased to welcome Sharmila Murthy. Professor Murthy joined Northeastern University in 2023 as Professor of Law and Public Policy in the School of Law and the College of Social Sciences. Her scholarship focuses on examining legal barriers to achieving environmental justice, improving access to water, and addressing climate change. During the Biden administration, she had a very busy job, served as Director of Environmental Justice and as a senior counsel at the White House Council on Environmental Quality. Prior to joining Northeastern's faculty, she served as Professor of Law and Director of Faculty Scholarship and Research at Suffolk University Law School. While she was there, I had the privilege of working with her on several projects while I was at the Massachusetts Attorney General's office. And in recognition of her scholarship on access to drinking water and sanitation and on climate change, she was named a Haub Environmental Law Distinguished Junior Scholar by the Elizabeth Haub School of Law at Pace. And while at Suffolk, she received a number of awards for her scholarship teaching and mentorship. She has other acclaims and recognitions and board memberships that you can check out on her online bio at Northeastern. She received her JD from Harvard Law School, her MPA from Harvard Kennedy School of Government, and her Bachelor in Sciences from Natural Resources from Cornell University. She clerked for the Honorable Martha Craig Dougherty on the U.S. Court of Appeals for the Sixth Circuit and was also a U.S. Fulbright Scholar in India. Today, she will present a talk on sustaining environmental justice. Please join me in welcoming Sharmila Murthy.
Thank you so much, Christophe, and many thanks to you and Courtney for putting this on. I'm just delighted to be with you all today. My talk today on sustaining environmental justice builds on a fantastic talk that my friend and colleague Marian Engelman-Lado gave last week as part of your Hot Topics series. And Marian and I worked closely together when she was at the EPA and I was at the White House Council on Environmental Quality during the Biden-Harris administration. And my talk today, Sustaining Environmental Justice, is going to build on and complement her talk, Advancing Environmental Justice in a Chaotic Time. So my talk today proceeds in two parts. The first is I want to explain this concept of norm sustaining. And then I want to talk about the importance of sustaining norms to advance environmental justice for all at this particular moment in time. So to explain the concept of norm sustaining, I actually want to take you back about a decade to 2015, when the Paris Agreement on Climate Change was first adopted by the international community, and under then President Obama, the US became a signatory to the Paris Agreement on Climate Change. But then in 2017, when President Trump took office for the first time, he announced that the US would be withdrawing from that treaty. Now, in response, there was quite a lot of outcry, including by states and cities. And so you had many states forming together to create the US Climate Alliance, which was a bipartisan coalition of governors that were seeking to address the goals of the Paris Agreement on climate change and pledge to try and achieve those goals. Similarly, at the local level, you had mayors pledging to uphold the Paris Agreement goals. And the question was, what did this all mean from the standpoint of international law? Because traditionally, since the Treaty of Westphalia in the 1600s, we've always thought about international law traditionally as between nation states. So what does it mean for states and cities to be pledging to uphold the goals of an international treaty? So in thinking through this question, I was really intrigued by a theory by Professor Harold Coe of Yale University called the theory of transnational legal process, which offered a different view on international law, that it was a hybrid body of international and domestic law that was not generated solely by nation states, but by a multiple of actors from the private sector, the nonprofit sector, from states and cities. And all of these interactions were together helping to internalize international law into domestic law. And transnational legal process theory really focuses on how law influences why nations obey. And I want to read to you a quote from one of his early papers on this topic. Coe's transnational legal process theory predicts that nations will come into compliance with international norms if transnational legal processes are aggressively triggered by other transnational actors in a way that forces interaction in forums capable of generating norms, followed by norm internalization. So let's try and break down what that means with a simple analogy. Imagine that you are driving in a residential neighborhood at night and you see a stop sign. There are no cops nearby. There is actually no one else driving on the street. You're the only one there. You see the stop sign. Do you stop? If you stop, you can understand that as a process of true norm internalization. And in the same way, we can think about the fact that nations may in fact be acting a certain way because they are internalizing certain norms. Now, this idea of norms was not new to the international literature. You actually had terms like norm entrepreneurs and norm sponsors. So, for example, when NGOs encourage governments to push for new ideas, they're often described as norm entrepreneurs. When nations then take those new ideas into treaty negotiations, they're described as norm sponsors, but neither of these terms really seems to explain what was happening when you had states forming the US Climate Alliance and mayors and other local actors trying to pledge to uphold the Paris Agreement on climate change. And what I've suggested is that they are actually acting as norm sustainers, and that they are actually reinforcing and contributing to international law in three distinct ways. So, first, by publicly benchmarking their progress against US targets, they could foster compliance by other nation states. And especially when you have a big economy like California pledging to uphold the Paris Agreement on climate change, that would certainly have an impact on other nations. Second, strengthening key norms of international environmental law. So, for example, a key principle like common but differentiated responsibilities and respective capabilities, recognizing that countries have different backgrounds, have contributed differently to the problem, and also have differing abilities to respond to that problem. And third, demonstrating feasibility of climate actions to lay the groundwork for national policy. Now, this is consistent with our model of federalism in the US, where states have long been understood to be laboratories for democracy. And here, the goal was for states and cities to be able to show that, yes, climate action was in fact feasible. So when we had another administration take office, we would be able to pick up where we had left off. So I outlined all of these ideas in a paper called States and Cities as Norm Sustainers, a role for subnational actors in the Paris Agreement on Climate Change that came out in 2019 in the Virginia Environmental Law Review. Now, the reason that I've been thinking a lot about this prior work that I did at this moment in time is because we are at another moment in time where we need to be thinking orders that really challenge the very norms that many of us have come to hold dear. And in many ways, following the Project 2025 playbook, which at one point, when it was first released, was seen as quite radical. And in many ways, through these executive orders, what we see the Trump administration doing is normalizing these otherwise radical ideas. So, for example, to pick some areas outside of the environment, we can look at immigration. We see that Trump, and just these are literally pulled from the headlines, the news headlines, that the Trump administration is deporting hundreds of immigrants, even as judges are ordering their removal to be stopped. We're seeing this in numerous instances. We're seeing attacks on students, on immigrant visas being the Trump administration trying to block their access to education. We're also seeing Trump attacking higher education, with the most notable example coming from my alma mater, Harvard University. And Trump has sought to cancel all federal funds directed at Harvard. And we're seeing other universities being concerned about this, researchers already beginning to self-censor and engage in anticipatory compliance because they're fearful about the power that the federal government is wielding, and in a way pushing against really fundamental norms that we have long held to be important, like the importance of federal funding for uh, academic research. Turning back to the environment, we are seeing massive rollbacks on important advancements so that the air we breathe is clean, so that the water we drink is safe. There are massive rollbacks happening in the name of deregulation, which is really going to allow polluters free rein and be harming the American people. In addition, hardly 6 months ago, the idea of diversity, equity, inclusion, and accessibility were actually norms that many people and many institutions prioritized and held dear. And yet now we're seeing attacks on DEI and on environmental justice, and in particular on a day one executive order under the guise of claiming that these programs are somehow discriminatory or illegal without any actual legal citations in the executive orders, trying to terminate those programs within the federal government and all of those offices. And we've all been watching the news and seeing the devastating impact on the federal workforce as well. So at this moment in time, this concept of norm sustaining is incredibly important. So while my earlier work had considered this with respect to international law, I'm now thinking about this concept of norm sustaining vis-a-vis the US domestic law. And in particular, what can we do in this moment in time to sustain norms to advance environmental justice for all? Now, the challenge is that during the second Trump administration, we don't actually have all of the same tools that we had before because of the continued attacks. So we see, for example, in April, President Trump issued yet another executive order protecting American energy from state overreach. And in doing so, he is tasking the Attorney General with identifying state and local laws that supposedly burden the development or use of domestic energy resources on the theory because that they may be unconstitutional, preempted by federal law, or otherwise unenforceable. Once again, there's no proof that these are actual valid legal claims, but rather by trying to speak them, he is trying to create law where it does not yet exist. Similarly, also prioritizing the identification of state laws that purport to address climate change or involve environmental, social, and governance initiatives, environmental justice, carbon or greenhouse gas emissions, and funds to collect carbon penalties or carbon taxes. So essentially, the same kind of reaction that we would hope to be seeing from states and cities may in fact be curbed somewhat by these very intentional actions that are directed at states and cities. Similarly, we see attacks at many other institutions that are critical for keeping an authoritarian regime in check. These are law firms, universities, civil society groups. We have all seen and maybe personally experiencing the impact and the brunt of these attacks and cuts in funding. And it's with this in mind that I see myself as having an obligation to actually do what I can to sustain norms to advance environmental justice. And as someone who is sitting in a university, who also had the privilege to work at the White House Council on Environmental Quality during the Biden and Harris administration to advance environmental justice, I want to take this moment to actually share the historic work that we were able to accomplish to advance environmental justice. Because if we do not document this history, if we do not analyze and share lessons learned from what worked well and what didn't, then we will wind up reinventing the wheel at a future date. Instead, we need to keep these norms alive so that when we have another president in office who's actually going to be advancing environmental justice for all, that we are able to pick up from where we left off. So with that, I would like to turn to the second part of my presentation and really briefly walk you through some of the key initiatives that were undertaken on environmental justice during the Biden-Harris administration. But I want to first start with a brief history of environmental justice and some seminal executive orders. Before I jump in, let me just pause and say that Marian Engelman-Lotto, in her Hot Topics talk last week, which is also available on the Vermont Law website, does a great job of discussing the history of environmental justice. And so I'm going to very quickly hit some highlights, but I will refer you to her talk for a more fulsome discussion. In 1994, President Clinton signed Executive Order 12898 on federal actions to address environmental justice in minority populations and low-income populations. This was really seen as the seminal executive order that really showcased the federal government's attention to environmental justice. And in particular, it directed federal agencies to address the disproportionately high and adverse human health and environmental effects on populations that had long been overburdened by pollution and otherwise neglected. But the federal government did not do this out of the blue. Rather, they were really responding to decades of activism and action by civil society in communities to protest the unfair siting of toxic waste and other chemicals and other hazards in communities that were largely communities of color and low-income communities. And in particular, the protests in Warren County in North Carolina around the dumping of PCBs really sparked national attention and galvanized the environmental justice movement. In addition, there were key reports by civil society groups, including the United Church of Christ, which issued Toxic Wastes and Race in the United States, a national report on the racial and socioeconomic characteristics of communities with hazardous waste sites. So really creating the evidentiary basis for showing that not all communities are being treated fairly in our country. The federal government began to take notice even before the 1990s. In the 1980s, you had the General Accounting Office also issuing a report on the siting of hazardous waste landfills and their correlation with racial and economic status of surrounding communities. And as a result of the 1994 Executive Order 12898 that President Clinton signed on environmental justice, you had the federal government begin to take meaningful steps to really address those disproportionately high and adverse human health and environmental effects on communities. And here's one example of the kind of work that was done. So the Federal Interagency Working Group on Environmental Justice was created by Executive Order 12898. And it, for example, developed reports, including this one on promising practices for EJ methodologies in NEPA reviews. NEPA is the National Environmental Policy Act, and the environmental reviews that are required under NEPA was a really important place for federal agencies to be thinking about effects, in particular on communities of color, low-income communities, tribal communities, and others. In addition, you had in 2011 a memorandum of understanding on environmental justice and Executive Order 12898 that many federal agencies signed. They were recommitting to uphold the key tenets of Executive Order 12898. And in addition, this also included agencies that weren't mentioned in President Clinton's executive order, such as the Department of Homeland Security, which didn't even exist at that moment in time. And of course, you had agencies like the EPA really trying to lead the way on environmental justice. But there had not actually been any presidential action per se since 1994 when President Clinton signed 12898 until President Biden took office. And you can still find on the Biden White House archives the website that our team put together that really documents and outlines all of our work on environmental justice. So feel free to take a look at that after this talk. I'm going to focus today on two of the key executive orders that President Biden signed to advance environmental justice. But I want to say that he actually signed seven executive orders to advance environmental justice. And in various ways, this was really about creating a whole of government effort and seeing the many ways in which environmental justice really does impact so many different issues and topics. But let me first start with the key initiatives that were developed under 14008, which was an order that President Biden signed within his first week in office, and it was on tackling our climate crisis at home and abroad. And it was a very large, long executive order, and it had an entire section on securing environmental justice and spurring economic opportunity. And I want to pause for a minute and actually just note the importance of bringing together these two concepts, that spurring economic opportunity is so central to environmental justice, which has historically been focused on addressing those disproportionately high and adverse human health and environmental effects, as well as meaningful involvement. But in addition, President Biden really saw the flip side of the coin here, that it's not just about addressing harms, it's also about understanding who is sharing in the benefits of investments. And he created something called the Justice 40 Initiative, which set a goal that 40% of the overall benefits of certain federal investments would flow to disadvantaged communities that are marginalized by underinvestment and overburdened by pollution. This applied to investments in clean energy, climate, clean transit, housing, legacy pollution, water infrastructure, and training and workforce development. This was not a pot of money, but rather thanks to the bipartisan infrastructure law, the Inflation Reduction Act, and others, there was in fact an infusion of funds, and the goal was to ensure that those funds and investments would in fact be shared more equitably. This required agencies to really think about how they were implementing their programs and making a series of changes to ensure that they were actually getting funds out to communities that might have otherwise been neglected or disadvantaged. It applied to new and existing programs, and as well to discretionary as well as formula funded programs. So in January of 2025, just within his last few weeks in office, President Biden did in fact launch a Justice 40 website. And these are some screenshots from a website that is no longer up, but if you'd like more info on it, I'd be happy to share some additional details. Through the Justice 40 initiative, which was really part of President Biden's historic Investing in America agenda, more than 500 programs across 19 federal agencies were identified, and that in fact, these programs reached and exceeded that goal of trying to target investments, the benefits of investments to disadvantaged communities. Here are two examples of how the Justice 40 initiative worked. So you had, for example, the Department of Homeland Security showcased on this website a project in Texas in Harris County Flood Control District buyout project. And essentially, this county in Harris County, a community in Harris County, Texas, faced repetitive flooding. And there were so many flood loss claims submitted, and ultimately, the flood-prone area was to be restored, and the larger community would be protected from future flooding events. Moving over to Ohio, the Department of Energy was also proud of a program that sought to establish Ohio's inaugural net zero energy neighborhood. And it really sought to create its first net zero energy disadvantaged community in the nation and to conduct comprehensive energy efficiency renovations on historical homes that hadn't been modernized. So these are just two examples of the Justice 40 initiative that was really seeking to target the benefits of investments in climate clean energy and other areas, at 40% of those to disadvantaged communities. This term disadvantaged communities was a term of art, and we used a tool called the Climate and Economic Justice Screening Tool to help identify those communities. This website was also taken down, but you can find an unofficial copy available at this website here, screening-tools.com. It was an interactive mapping tool designed to identify disadvantaged communities at the census tract level. It applied to the entire US, including the District of Columbia and the US territories. It used environmental, climate, socioeconomic data, and other data sets to create indicators of burden. And in addition, land within the boundaries of federally recognized tribes, including Alaska Native villages, were highlighted as disadvantaged. This was a really lovely website that was very easy to use. You can, as I said, you can still see an offline version of it at screening-tools.com. This is just a snapshot that shows you how the indicators were shown, and you could click onto any of these blue rows here, and you would get additional information about the burdens that a particular community was experiencing. This is an example of a notice of funding that here, an example from the Department of Energy that would show an example of discretionary funding. And it shows how agencies were using the Climate and Economic Justice Screening Tool, for example, asking applicants to describe if any of those tracts were in fact included in their recipient populations. So I've just talked about the Justice 40 initiative and the Climate and Economic Justice Screening Tool. I am now turning to a third initiative that was called the Environmental Justice Scorecard. Now, this was a tremendously important initiative as well, because it really underscored the commitment of the Biden-Harris administration to transparency and to actually having information shared with the public about what federal agencies were doing. And so this was a very robust website that, once again, is no longer up. But if you'd like more information about how to access some of the underlying data, I'm happy to share that with you offline. But it had metrics and information from a whole number of agencies relating to the Justice 40 initiative, environmental and civil rights protection, in particular, the National Environmental Policy Act, Title VI of the Civil Rights Act, centering environmental justice in decision-making, consultation and partnership with tribal nations, and also institutionalizing environmental justice. And it was a tremendous effort because federal agencies do not actually always collect the same kind of data. And so even trying to begin to standardize the kind of data that was being collected across the federal government was in and of itself a really important task. In addition, for really all of our initiatives, we valued public feedback. And this is just an example of a request for information that we put out to solicit feedback on the Environmental Justice Scorecard. We had similar requests for information on the Climate and Economic Justice Screening Tool and other initiatives. Let me now move on into talking about some of the key actors that helped to make this work possible. Within the federal government, there's a really critical role for interagency bodies that actually help agencies work across silos and work across boundaries. And because President Biden had set environmental justice as a whole of government initiative, what he did is he elevated environmental justice by taking the pre-existing interagency working group on environmental justice and renaming it the White House Environmental Justice Interagency Council, which was then directed by Chair Brenda Mallory, who was the chair of the White House Council on Environmental Quality. And this was really important because it really tried to elevate and tried to enhance the coordination across the federal government on this important initiative. So this is just a screenshot from our old website on that showed all of the principles. But in fact, the day-to-day work was done by lots of very hardworking staff, including many career staff who have since lost their jobs because of the rollbacks that are happening right now in the federal government. So we have a number of federal departments as well as White House components that were very active in to coordinate this work. In addition, the Biden-Harris administration took very seriously the fact that we needed to hear from community members. And in particular, it created, under the Federal Advisory Committee Act, the White House Environmental Justice Advisory Council. So these were leaders from nonprofit groups, from the private sector, from state and local governments and tribes, from academic professors, and other representatives that really provided an important voice to the federal government. And in particular, this is just an example of very detailed recommendations that they would provide to the federal government that we at CEQ would then share with our federal partners. The WEJAC also held public meetings that were very well attended and provided an opportunity for members of the public to share their thoughts with the federal government. Tremendously important work. In addition, our team worked really hard to try to convene together the federal government together with members of the public and different stakeholder groups. And we're so proud when we were able to hold the White House Summit on Environmental Justice in Action. And it's hard to believe that that was basically just a year ago that happened. So let me turn to the next executive order. And in some ways, you can see that I think about this somewhat chronologically because I was at the White House Council on Environmental Quality from 2021 through 2024. And so in many ways, I'm sharing with you the way in which I was experiencing this work. And so we had, this is the chronological listing of President Biden's executive orders. And in March of 2024, he signed Revitalizing Our Nation's Commitment to Environmental Justice for All, Executive Order 14096. Sorry, in 2023, I should say, he signed that. And this in 2023 led to a number of key changes. First, this executive order institutionalized the White House Office of Environmental Justice, and that was our team, and created a new position, the Federal Chief Environmental Justice Officer, led by Dr. Jalan White Newsome, who I was privileged to work with. In addition, Executive Order 14096 created a federal government-wide definition of environmental justice. Now, for a long time, EPA had a definition that was used by EPA and some other agencies used it, but there had never actually been a government-wide definition of environmental justice. And I want to just highlight why this definition is so important. First of all, this definition builds on recommendations that were provided by the White House Environmental Justice Advisory Council. And you can go and look at those original recommendations. They are still available, not officially on a government website, but they are still available online. And some of these, you will see that there is how this definition was inspired by their recommendations. It talks about just treatment and meaningful involvement. So both sort of substantive and procedural aspects of environmental justice of all people, regardless of income, race, color, national origin, tribal affiliation, or disability. This is important. This was about environmental justice for all, not just focused on particular communities, but really thinking about how do we ensure that everyone has access to clean air, clean water, a safe place to live and play. And focused again on federal activities that affect human health and the environment so that people are fully protected from disproportionate and adverse human health and environmental effects. And the second part of this bullet are really important because it signals the way in which environmental justice is so connected to other issues. A call out to climate change. There was a call out to cumulative impacts, so important. And then also recognizing the legacy of racism or other structural or systemic barriers. And these are real, even in the face of changing norms that the Trump administration is now trying to do, that we still do have the legacy of racism and other structural and systemic barriers that are affecting communities today. In addition, speaking to that second half of the coin, when I talked about the Justice 40 initiative earlier, I mentioned how important it was that President Biden was also thinking about ensuring that communities were sharing in the benefits of environmental protections and investments. So you see that reflected in sub-bullet number 2, that they have equitable access to a healthy, sustainable, and resilient environment in which to live, play, work, learn, grow, worship, and engage in cultural and subsistence practices. A really robust definition. This executive order has been revoked actually numerous times by President Trump. But the point is that this definition is still out there. It still exists. And one day, if we can keep these norms sustained, we'll once again hopefully have meaning for the federal government. Another key element of Executive Order 14096, signed in 2023, was an effort to ensure that federal agencies were thinking critically about how to advance environmental justice in all of their operations. And a key way to do that was through strategic planning. And so in October of 2023, we had issued interim guidance to our federal agency partners that was called Strategic Planning to Advance Environmental Justice. And this was a template and a playbook for agencies to follow. And I'm proud to say that we actually had a lot of agencies actually issue their environmental justice strategic plans, even though they were doing so in the fall of 2024. And these number of agencies that are listed here all actually published their plans, even recognizing in some instances that there was a new administration coming into office. They still saw it as critically important to be able to articulate for the American public how it was that they were going to be advancing environmental justice for all people. In addition, under the Biden-Harris administration, another really key aspect was heightened attention to science and data. And through the Office of Science and Technology technology policy, that arm of the White House, the Executive Order 14096 created an environmental justice subcommittee of the National Science and Technology Council. And this brought together experts, scientists, researchers, experts across the federal government to really think critically about how they could better advance science, data, and research to advance environmental justice. And in July of 2024, almost a year ago, they released a tremendous report that, once again, you can still find available unofficially or through the archives. I want to now turn to another key aspect of Executive Order 14096, which is the way in which it incorporated key statutes. When President Clinton signed Executive Order 12898 back in 1994, the actual executive order did not contain any references to statutes. Instead, he issued an accompanying memorandum to federal agencies that highlighted the importance of, in particular, the National Environmental Policy Act, or NEPA, and Title VI of the Civil Rights Act. When President Biden signed Executive Order 14096 in 2023, that executive order actually specifically references these statutes because the goal was, in many ways, to show exactly how environmental justice is, in fact, supported by legal authorities, many different legal authorities, but in particular, these two. And as a result, we saw a commitment. We saw agencies taking action to advance environmental justice through their work under the National Environmental Policy Act, as well as the administration finalizing the NEPA regulations. And this is just a press release that was issued in April of 2024. The Biden-Harris administration finalizes reforms to modernize environmental reviews, accelerate America's clean energy future, simplify the process to rebuild our nation's infrastructure, and strengthen public engagement. This was how the Biden-Harris administration was really celebrating the revised NEPA regulations that, among other things, incorporated the definition of environmental justice that tracks with Executive Order 14096. Now, of course, just shortly after taking office, President Trump's administration almost immediately sought to remove the NEPA implementing regulations and did so in a way, an unusual way, through an interim final rule that also just suggests a broader concern around just fidelity to the Administrative Procedures Act and how rulemaking really should be done. But the NEPA regulations were removed through this interim final rule. I mentioned Title VI of the Civil Rights Act. I want to just say a word about why Title VI of the Civil Rights Act is seen as so relevant to environmental justice. These are excerpts from a U.S. Department of Justice manual on Title VI that is still available online. And here's two quotes. Disparate impact regulations seek to ensure that programs accepting federal money are not administered in a way that perpetuates the repercussions of past discrimination. The Supreme Court has repeatedly held that Title VI regulations validly prohibit practices having a discriminatory effect on protected groups, even if the actions or practices are not intentionally discriminatory. So, disparate impact has long been seen as a very critical tool for addressing environmental justice, these regulations, but we see the Trump administration taking aim at these long-standing regulations. So, for example, in an executive order from just this past April called Restoring Equality of Opportunity and Meritocracy, taking aim at the Civil Rights Act of 1964, among other non-discrimination laws. And as a result, we're seeing federal agencies already beginning to try and roll back long-standing protections on non-discrimination, such as DOE's Department of Energy's recently promulgated direct final rule on rescinding regulations related to non-discrimination in federally assisted programs or activities. And once again, the use of a direct final rule as opposed to a traditional notice of proposed rulemaking also just suggests a tremendous disregard by this Trump administration for the Administrative Procedures Act and for traditional legal processes. So in my time, I have really done a whirlwind of a review of some of the key initiatives that we did to advance environmental justice in the Biden-Harris administration. And at this moment in time, when we are seeing such a rollback on so many fronts, on environmental protections, on immigration, on the rule of law, on due process, we are seeing a fundamental shift in the norms that we have once held sacred as a society. it's important to understand this concept of norm sustaining and really understand ways that we can be sustaining norms to advance environmental justice for all. And I want to leave you on a perhaps, hopefully, somewhat optimistic note to say that we do have a voice, we do have a role here. So, together with my colleagues, former colleagues at the White House Council on Environmental Quality, as well as Marian Engelman Lotto of the EPA, we wrote a blog a few months ago called Environmental Justice is Not About Them. It's about all of us. And we ended the blog with a few things that people can do. You can write to your elected representatives and let them know you stand for greater health and environmental protections for all. You can tell your state and local leaders to develop stronger laws, regulations, and programs on environmental justice. And in particular, this was actually written before the latest executive orders attacking states and cities. You can try to stand with your local and state leaders to withstand attacks by the federal government. You can volunteer with your local environmental justice organizations. Because despite the Trump administration's rhetoric, environmental justice is not about them. It's not about an other. It's about making sure no child is exposed to lead in water. It's about making sure no family fears that the air they are breathing is poisoning them. It's about all of us. And for those of us that are academics like I am, we also have an obligation to keep telling this important story, to keep writing about the importance of environmental justice protections for all people. Because if we don't sustain these norms, who will? And with that, I'd like to say thank you. If you have any questions or would like to follow up with me, please feel free to reach out to me. My email is online. Thanks.
Thank you, Sharmila. That was wonderful. And there's so many topics, so many rich questions and next steps and all sorts of things to think through that your talk raised for me. But I certainly want to welcome, we have a few minutes for questions. If you do have a question, please, and you're watching live, please enter it on YouTube on the right-hand side of the page, and I'll share it with our guest. But I'll get us started by sort of asking about this question of sort of durability and the need for sustaining these, policies and principles and definitions and all this incredible hard work that you and your colleagues in the federal government during the last administration did. And I guess my question is, how much of those efforts were built, informed by this principle? And how are you looking at the task of rebuilding and restoration if that opportunity arises?
Thank you so much for that question. I think it goes without saying that the federal government was really inspired by efforts that were taking place at the state and local level. So we had, states like California, Massachusetts, Vermont, New York, Maryland, other states that had, for example, whether it was initiatives like the Justice 40 initiative, like the Climate and Economic Justice Screening Tool, that saw the need for transparency, that saw the need to be engaging with the community. So I think it's incredibly important in whatever form or shape to try and keep those efforts alive, which is why I think this latest, this executive order that's specifically trying to go after states and cities is particularly problematic because in many ways really counteracts the fundamental norm of our society, which is that we are a federal country of United States of America. And so I think, and there is a sound legal basis for those laws. And yet, what we see President Trump trying to do is just speak his thoughts into law, to basically pretend that what the law is. And if he says it, basically say and wait for people to challenge it. So first of all, I think it's incredibly important for us to try at whatever level of government is possible to maintain these norms. Similarly, to the extent civil society recognizing that a lot of nonprofit groups are struggling right now with funding cuts, but to the extent to which there are still they are able to, that the private sector is able to support this. I mean, they're the we were at the cusp of a real clean energy revolution. And there are private actors that would like to that recognize that they can do well and do good at the same time. And I'm hoping that we can really work together with folks like you and me who are in academic institutions. And we're seeing, an attack on so many institutions, including academics. And so I think it's just so important to just keep this message alive in whatever way we can.
I do have a couple questions that came in through the chat, so I'll ask them. With how quickly the Trump administration has rolled back all of these many initiatives, it was sort of a blitzkrieg in the first few months of, going back to Clinton's executive order. I mean, I think that surprised me when I saw that happen, given that it had been in place throughout the prior Trump administration, and there were environmental justice efforts that, for example, Administrator Scott Pruitt heralded during the first Trump administration. So there was a sense that that value wasn't going to go away, but it was quite a shocking effort to clear the books of all of these various principles. Can we, if in the sort of, to follow up on that restoration question, can we just reinstate them? Those executive orders, would that be the right thing to do? Or how you think about that question, the sort of ping pong quality that we've seen across environmental law over the last couple decades, but it's really it seems particularly acute in this context.
Yeah, it's a great question. And so first, I just want to pick up on a point in your question, you just mentioned Scott Pruitt. And I just want to first say that environmental protection is not and should not be a partisan issue. And that if you look back I mean, it was actually like President Nixon that signed the National Environmental Policy Act, right? And that somehow this has become a partisan issue in a way to me for unclear reasons, because these are really benefits that all people benefit when you actually have clean air and clean water and a clean place to live and work and play. Um, we have seen in history back and forths in terms of executive orders, being repealed and revoked and then coming back and you see when they get reinstated, they're not usually identical, but they build on a lot of that earlier language. I think I will say that the metaphor that I've been thinking about in my mind is that in many ways we see government burning to the ground right now with the Department of Government Efficiency, with so many career staff being let go, with entire departments being dismantled. And I keep thinking about that metaphor of the mythological phoenix rising from the ashes, and that perhaps one day we will, if we can keep these norms alive, we will actually be able to rise from the ashes, and that phoenix will in fact be a better version of what came before. So do I think that we should continue to study the work that we were able to do in the Biden-Harris administration? Yes. Do I think some things could be done better? Yes. And the hope is that through, I would love to invite other academics to really think about because there's so much attention now on the current moment and the rollbacks. And in some ways, it's perhaps less exciting to study what worked, what went well. But I'd really love to invite, in particular, academics and others that are sort of documenters of history to really not overlook this moment, because my fear is that we did all of this tremendous work and it's not even going to make it into the footnotes of the history books. It's all going to just be washed away as a, sort of failed policy experiment. And so, when we have a different administration come into office in the future, we're going to wind up starting from scratch again. So I think it's just in every way we can, I think we need to be keeping alive what happened, but not being Pollyanna about it, right? Being trying to think about how to actually have that phoenix rise from the ashes in a way that's really going to do justice to the concept of environmental justice.
Love that metaphor. One other question in the chat briefly. This question of disparate impacts. I worry in particular about that being one of those really bedrock concepts of civil rights law that, I worry that will be abandoned. So we have Gary in the chat asking, so what is the status of using Title VI to defend communities from disparate impacts? Because it was already, I think under strain before this administration. And we saw some opportunistic litigation that was, really impeding EPA's ability to enforce its regulations. So wondering if you have any quick thoughts on that.
Right. It's a great question. And so since the Sandoval case, there is no private right of action to enforce disparate impact, which sort of just suggests the importance of federal government agency regulations that have been on the books for decades on disparate impact. I think what is troubling at this moment is, for the Trump administration, the fact that they wouldn't want to spend their efforts on disparate impact and civil rights enforcement, I could understand that as a policy matter. What is problematic at this moment in time is that the way in which they are trying to go about doing this. So, for example, the DOE direct final rule that I mentioned, the fact that they are doing this as a direct final rule and saying this rule will be in effect unless we receive significant adverse comments. The fact that you could have long-standing civil rights protections in place and just assume that you're not going to have significant adverse comments is just somewhat mind-boggling. And it also shortcuts the really bedrock principles of the Administrative Procedures Act, where you should do a notice of proposed rulemaking, actually have a significant amount of time for comments, and then, go through the normal procedure. And we just see them really trying to run roughshod over sort of processes that are in place to ensure that we actually have the best outcome. And to me, it's not simply the policy decision that's troubling. It's the fact that, once again, fundamental norms about how we make policy and the value of public comment is being totally jettisoned at this moment.
Yes, it is the environmental injustice of not promoting environmental, participation in government decision making is, directly under attack using with these procedural mechanisms that the administration is using, which I think makes it all the more alarming. Final question for you, as we come close to the end of our hour together. For the students and other newer professionals who are looking out at this field and wondering where would their energies and efforts best be deployed while also earning an income and working on things that help their family succeed. How do you think about it with your students? How do you think about it for those newer professionals, including some of those that I'm sure you mentored, while you were during your time in the federal government? How do you think about advising and sharing next steps with them in particular, as they really are passionate? So many of them are so passionate about these issues. Went to law school or went to, did a graduate degree for the purpose of tackling these questions. What would be your advice to them?
So my heart goes out to everyone that is in this moment, and especially to all the law students and recent graduates that lost fellowships and had opportunities dry up because of what's happening. And in some ways, this was not a crisis that had to happen. It is really it's unclear why so many people have had to suffer in this way. If you are passionate about these issues, I just want to say that there are many ways to get involved even if you may not have the opportunity to have your dream job because either that federal agency doesn't exist or the organization you wanted to work for doesn't have the funding it needs anymore to be able to hire you. There are many ways, especially for those with a law degree, and I want to outline a few. Number one, you can always do pro bono work. And I will say that there are lots of great organizations like Lawyers for Good Government and others that have opportunities out there to be helping groups that are facing uh, denials of federal funding and trying to understand how to navigate somewhat complex systems. Number two, serve on the boards of nonprofit groups. That's another great way. And then, of course, just be active, write, and make your voice heard.
Well, that's terrific advice. And thank you again, Professor Murthy, for your presentation. And thanks to everyone who's joining us online. Our next talk will take place online Tuesday next week. Same place, just slightly different day, but same time as well. So have a good day, everyone. Thanks so much for your time.
Thank you. Bye.